Welcome to The Explainer. When you think about a big company, have you ever stopped and wondered who's really pulling the strings? Well, today, we're going to pull back the curtain on corporate governance. It's basically the secret rulebook that decides who has the power and, just as importantly, how they get to use it. So think about it. Here's the central puzzle. A public company can have thousands, even millions of owners, the shareholders. But only a tiny group of people are actually in the driver's seat. So how do you make sure those drivers are taking the company where it needs to go and not just taking everyone else for a ride? That is the absolute core question of corporate governance. All right, so the system's first line of defense is the board of directors. You can think of them as the elected representatives for all those owners. Their whole job is to keep a bird's eye view of the entire operation and make sure the company doesn't veer off track. Now, being a director is this incredible balancing act. On one hand, you're an agent. You have the power to sign deals, make commitments, and really bind the company. But on the other hand, you're a trustee. You're a guardian of the company's assets. So you hold the keys to the engine room and the vault. That is a massive amount of responsibility. But, not all directors play the same role. Most of them are there for oversight, attending board meetings to weigh in on the big picture strategy. But then you have the managing director, or the MD. This is the director who's on the ground every single day running the show with what the law calls substantial powers of management. They're the one in the trenches. And here's the thing, not just anyone can walk in and become a director. The law has some pretty serious bouncer rules at the boardroom door. For instance, you're out if a court has found you to be of unsound mind, if you're bankrupt, or if you've been convicted of a serious crime. On top of that, every director needs a unique director identification number, or DIN, so there's always a clear public record of who's in charge. And let me be clear, this is not a job for life. A director can be automatically kicked out. And one of the most interesting reasons, if you don't show up to a single board meeting for 12 straight months, poof, you're gone. It sends a really clear message, right? This job is about active participation, not just having a fancy title. Okay, so we've got the right people in the room. That's step one. But even with the most trustworthy people, you absolutely need rock-solid rules, especially when it comes to the money. So how does the system keep all the finances on the straight and narrow? And that brings us to the second major piece of this puzzle, financial accountability. These are the critical guardrails that are designed to protect the company's cash and make sure everything is transparent for the owners. For a lot of shareholders, this is what it's all about, the dividend. That's their piece of the pie. But there is a golden rule here. Dividends can only be paid out of actual earned profits. You can't just dip into the company's core capital to pay shareholders. This one rule is absolutely essential for keeping a company healthy and stable. And to make sure you can always, check the receipts, companies are required by law to keep their financial records for at least 8 years. That creates a long, long paper trail, ensuring that if anything ever looks fishy, you can go back and see exactly where the money went. Of course, businesses need to borrow money to grow, and when they do, they often issue something called a debenture. Honestly, the easiest way to think of this is just a formal IOU from the company to whoever is lending them the money. It's the official loan document. Now, here's where it gets really clever, how those loans are secured. A lender can take what's called a fixed charge on a specific asset, like the company's land. That land is locked down, the company can't sell it. But they can also use a floating charge over a whole class of assets that's always changing, like the inventory in a warehouse. The company can keep selling stuff, no problem. But if it defaults on the loan, that floating charge suddenly crystallizes and becomes fixed, locking down whatever inventory is left on the shelves at that moment. Pretty smart, right? So when you put all these rules together, the rules for directors, the rules for finances, they create this whole framework for good behavior. And within that framework, the system defaults to a really simple democratic idea, majority rules. In pretty much every decision, the will of the majority of shareholders prevails. Now, on the surface, that sounds perfectly fair, right? It's efficient, it's democratic, but this is where a huge potential problem creeps in. What happens when that majority doesn't just use its power to lead, but to dominate and oppress the minority? This idea is so fundamental, it's actually based on a famous old legal case. And the principle is this: courts generally don't want to get involved in the internal fights of a company. They prefer to let the company sort its own problems out, basically trusting the majority to do the right thing. And that, right there, leads us to the ultimate stress test of the entire system. It's all built on majority rule, but what happens when that rule becomes tyranny? What can you possibly do if you're a minority shareholder and you're getting steamrolled? This is where the system reveals its final and maybe most important feature, the ultimate safeguard. The law totally anticipates this problem, and it provides a really powerful set of tools specifically designed to protect the minority shareholders from abuse. The key legal idea here is something called oppression. Now, this isn't just about you disagreeing with a business decision. Oh, no. Oppression is conduct that is defined as burdensome, harsh, and wrongful. We're talking about behavior that is fundamentally unfair and is actively harming the company or some of its members. And this isn't just some abstract theory. There is a real path to fight back. Shareholders can take their case to a special court called the National Company Law Tribunal. There is a catch, though. You can't just go it alone. You need to show it's a real problem by getting at least 100 members or 1/10 of the total members to back your case before the tribunal will hear it. And believe me, this tribunal is not a paper tiger. It has real teeth. You can think of it like a corporate panic button. It can step in and issue some seriously powerful orders. We're talking about firing the MD, canceling shady deals, and maybe the most powerful of all, it can actually force the majority to buy out the minority shareholders at a fair price, giving them a clean exit. So as you can see, from the boardroom to the bank, corporate governance is this fascinating web of checks and balances, all designed to try and keep things fair. But it leaves us with this one big, lingering question that gets debated in companies every single day. Where exactly is the line between a fair majority decision and outright oppression? Finding that line, that is the constant high-stakes game at the very heart of how businesses are run.